Peace to the gods. You're listening to Hindsight Radio.
Peace, everybody. This is your host, Akeem Mel from Hindsight Radio, the information station changing the nation. As you know, I have a show every Tuesday on Blog Talk Radio at 7 p.m. Eastern Time. You can log in at blogtalkradio.com/Hindsight 2020. Today, I'm going to make a short video on some statements made from that congressional record that I've been reading over the last few weeks. I did 2 videos. This is the third part. And there's something striking in the statements of a particular professor. The statements of Vine Deloria, professor, University of Arizona, Tucson, Arizona. All right, here we go. It says, Mr. Deloria. Thank you, Senator Inouye. I delayed my testimony because it doesn't directly relate to the Iroquois situation. I want to thank you for introducing the resolution, and I would like to make some suggestions about how in the next couple of years some of the spirit of the resolution can be carried out. Quite often, the Congress and political theorists describe the United States as a system of checks and balances where the 3 branches of government work together and place limitations on each other. The problem that American Indians have is that checks and balances really don't work with Indian tribes. American history shows that when dealing with Indians, the 3 branches defer to each other. The ultimate difference between being to the Congress and no checks and balances exists. The Congress, at least in the last 100 years, in my opinion, has transferred a good deal of its legislative authority to the federal bureaucracy by attaching to legislation. In most instances, the authority to promulgate rules and regulations to carry out the effect of the statute. The net result is that there are no protections for Indian people, their rights, or their property. The bureaucracy, in effect, makes up the rules under which Indians live. The courts pick up on bureaucratic practices and declare that long-established administrative practices are evident of the intent of Congress. As a result, the protections granted all other Americans under the Constitution never come into play with Indian people, and we have seen our status go from dependent domestic nations to virtually helpless wards of the government, where in some instances it takes the signatures of up to 20 bureaucrats to use a piece of Indian land. The Arizona Republic has recently come out with a series of articles on the Bureau of Indian Affairs in the federal administration. In my youth, we used to call the Bureau a hotbed of inertia, but today I think you could call it a crime in progress if the stories in the Republic have any validity. I suggest you go find those archives of that newspaper. Arizona Republic is a newspaper. All right, let me keep going. My concern at this hearing is that we can do all the investigations and newspaper reports that we want, but ultimately, there will have to be certain fundamental structural changes involved in the definition of the Indian federal relationship, one of which is clear definition of the status of Indian tribes. If the United States is a government of consent, then I think we look at American history at what point Indians consented to have relations with the United States and to place themselves under federal protection. See, it said, let me read again. If the United States is a government of consent, that is very powerful. That's remedy there. Everything's by consent. But somehow we are under the illusion that we have to do something. It says here, it's supposed to be a government by consent. All right, let me keep reading. This point can only be found as a voluntary expression in the Indian treaties. And those treaties were supposed to be the supreme law of the land. That is in the Constitution, Article 1. However, we have seen the treaties since 1870 be consistently overruled by subsequent congressional statute. Now, when I speak of courts deferring to Congress or the executive deferring to Congress, the most frequent situation we have is where Congress passes a statute not believing that it is in conflict with an Indian right of property, and a subsequent controversy arises and Indians go to court. The court defers to Congress in the sense of recognizing the plenary power of Congress over Indians. And the court then creates a fictional scenario in which they create a fictional intent of Congress. The best example I can think of is the debate on federal water rights in the 1950s, where it was clear that Indian property would not come under the McCarran Amendment. But subsequent litigation interpreted the McCarran Amendment to apply to Indian rights because they had an aspect of federal protection to them. And we are included in the bundle of federal rights. In Lone Wolf versus Hitchcock and a number of other classic Indian cases, we have instances in which the Supreme Court of the United States simply creates legal doctrines that give Congress overwhelming power over Indian tribes and in effect overrule treaties. Although it is never clear in the actual statute in question that Congress ever intended to overrule any Indian treaties. I would suggest the best parallel of the relationship of tribes to the United States is the 10th Amendment, and that is the U.S. government is a government of delegated powers, delegated by the people, delegated by the states to the federal government. All powers not delegated to the federal government are reserved to the states or the people respectively. In like manner, the Indian treaties are a delegation of certain rights and properties to the United States with a withholding of similar rights and properties to the Indian tribes. That doctrine enunciated in the Northwest Fishing Rights case U.S. versus Winters says anything not delegated to the United States must be reserved to the tribes and the people of the tribes. So there's a definite legal status to being a dependent domestic nation. But unless we have a clear statement by Congress of what this relationship is, we will continue to be forced into expensive litigation in which the federal courts have an absolutely free hand to announce strange doctrines constructed only with the intent of reconciling a long-standing treaty right with a congressional statute, with the history of congressional statutes showing that there was no effort by Congress to discuss Indian rights prior to its passage. Additionally, we have other doctrines of interpretation that are used in federal court when interpreting primarily general legislation that I think are extremely detrimental to Indian tribes. We need clarification of those. Basically, what is being said here is that they have treaties that clearly outline the rights of the indigenous people. Now, what happens is they go into litigation and the courts are interpreting it in the favor of Congress, or their favor in determining these cases to the detriment of the indigenous people. It's a clear intent to overrule what is supposed to be the supreme law of the land, which is treaty. And after treaties, then you have constitution. But what are they doing? They're hiring lawyers to go in here and fight these causes. And you know what happens when you have a lawyer. They will muddy the waters. And if they are a lawyer that is hired or works under the system of the United States, they're going to do whatever they can to work for that system. So if we need to get remedy, we can't go to their lawyers to do this. We're going to have to do this on our own. You see, you're going to have to go to the court as the people, or as the people who has these rights, and make your demands. Okay? You have some guy with a bar club card draft up these motions, and you're going to fall right into the trap so many fall into. What? To someone's opinion. It's not about opinion. It's about certified copies of these treaties and entering them. And the facts are clear. No matter what statute they put in place. See, what they're doing is taking statute and making that the law. And it's not. All right? Let me keep going. The logic in a lot of these interpretations is deadly, inescapable, and unjust. If Congress intended to include the Indians in this legislation, it would have specifically said so. So what he's saying is the legislation doesn't apply to the Indians. So why are they using the legislation and fighting in making these determinations? When they draft these statutes or these laws, as they call it, or these legal ideas, then the indigenous people are not in mind. So what does it say in the Constitution? Indians not taxed. Indigenous people are not included in these laws. That's what it's actually saying right here. They don't have them in mind. They have their citizens, their people to have jurisdiction over. Okay? All right. The reverse of that coin is that if Congress had intended to exclude Indians, it would have specifically said so. All of us in this room can see the arbitrary nature of law when a judge has the option to say you are either inside or outside the confines of the law, depending on whether I choose to create the fiction that if Congress had wanted to include you, they would have mentioned you. If they wanted to exclude you, they would have mentioned you. Very powerful statement there. As long as legal doctrines like that are used freely in the courts of the United States, there will be no end to litigation. There will be no solution to Indian problems. With the federal bureaucracy vested with almost unlimited powers, Indian tribes at this point must have some vested rights under the Constitution to protect themselves. See, that's why it's very important on how do you identify yourself. What's your nationality? Are you black, African American, white? All of these titles that they created, those are U.S. titles, U.S. person titles. So if you identify that, then you are up under that. If you're identifying with that. You see? That's why I have made it my mission to show you guys how to identify yourselves properly. and clear the record. Okay, clear it. See, people have been teaching you guys, oh, just don't mess with that. Don't. Yes, I in some instances I agree, but in other instances, if you have been living a lie as this fiction that they created, you got to go undo that. You can't just, oh, I'm out of here, I'm out of it. No, you got to undo all of those connections you have made and say, here, I am setting the record straight, so on and so forth. Okay? The only way we can vest those rights in a series of clear congressional directives, these directives would be to the government as a whole. They would have to be recognized in the federal courts as doctrines of interpretation which express the intent of Congress. Doctrines which must be followed in hearing, resolving Indian litigations. These would be doctrines that should be followed by people in the federal bureaucracy. These would be doctrines that would hopefully be followed by subsequent administrations and executive offices. I would suggest that most needed doctrine at the present time is a clear statement that unless Congress specifically examines Indian treaty rights or outstanding statutory rights and specifically includes Indians, that it specifically includes Indians in legislation, national legislation does not apply to Indian tribes. If we had that directive, we could eliminate a good deal of litigation that is going on today. But we have to have a clear statement so that one, we minimize litigation, and two, when we go to court, we have an even chance of getting a resolution of the problem. One of the big problems that we additionally face is the recognition that the original treaty relationship was a relationship of consent following the cession of treaty making in 1871. The right of Indian consent was gradually whittled down by bureaucratic inroads. In recent times, particularly beginning with the 1934 Indian Reorganization Act, the idea that Indians should be consulted before legislation or programs for them were put forth became very popular. This was very popular in the 1960s when the poverty wars were going on and people were saying that you should consult the poor before you proceed. The current state of Indian affairs shows consultation is a myth. When you view it from the bureaucratic standpoint, consultation merely means that you try to talk the Indians into what you want to do. Following that meeting, you proceed to do what you want to do anyway. What we need is a federal statute saying that there must be an Indian consent before any program of the federal government can be operated on a reservation or operated in a manner that would affect Indian rights. We need the right to say no to federal statutes insofar as they are effective on the reservation. The IRA is interpreted as meaning that the word of the Secretary of Interior is the dominant word on the reservation and that the Secretary of the Interior must approve all tribal resolutions passed. What we need is a statute saying that if a tribal council votes no, then the decision of the Secretary of the Interior is not the law for the reservation. The decision of the tribal council is. This change will prove controversial in a number of cases, but unless we have some checks and balances to protect ourselves against the federal bureaucracy, there is no way that anything is going to change out on those reservations. The bureaucrats simply make up the rules as they go along. I could cite chapter and verse for the rest of the year on conflicting interpretations of federal law given at different area offices at the different times with regard to the same thing. But there's a final thing that I think must really be considered, and that is that the question of the honor of the United States. Its relationship to Indians has to be raised in a congressional context. The treaties are more than a legal document. They are a pledge of the integrity of one people to another. We have seen the integrity of the United States badly eroded on the justification that there were certain expedient things to be accomplished. The frontier has been settled for quite a while, and we are now approaching the 500th anniversary of the landing of Columbus. So 500 years of contact with Western European civilization is enough. We need some protection so that we can continue our own existence. Honor and integrity require that Congress follow up on oversight hearings on everything that the federal bureaucracy does. Let me cite you two examples of what I consider almost criminal congressional negligence. The Indian Claims Commission Act was passed in 1946. It was intended to be a commission, and the premises of that act was that within 5 years in open and informal hearings, the commission could look at the Indian claims and reach some just settlement. Section 13, I believe it was gave that the commission investigatory powers, and the commission was supposed to look at all the claims in an informal layman's equitable eye and determine the validity and scope of those claims. The Claims Commission, within 5 years of its founding, was turned into another federal court with all the federal court procedures. The investigative decision or function of the commission was simply truncated. It got so bad that Commissioner John Vance in the late 1970s published an article saying that what the Claims Commission was doing was ridiculous. He first pointed out that instead of a commission fairly hearing claims, the commission had been turned into a federal court in which lawyers dominated. Here you go. Lawyers dominated, and Indians were not allowed to speak their piece. What is that paragraph saying? They get the lawyer involved. Now you can't speak your rights. Okay? This is what's happening. And this is not happening just in these cases. This is happening in all cases, where you have supposedly paid this guy to help you. He actually screws you. It is no secret to any of us that there are a lot of mad Indians out in the United States. My own tribe, the Shoshones, and others who feel they have been unjustly handled by the Indian Claims Commission. If you look at the response of Congress after it authorized the Indian Claims Commission, it is negligent and negligible. Not once did it go back and call those commissioners to account for turning the commission into a court instead of a commission. In several hearings that were held, renewing the Claims Commission simply concentrated on what additional procedures might be needed in order to resolve the claims. As a result, claims turned into simply money judgments against the United States. The right to religion, the right to culture, the right to self-government never came up in the Claims Commission. This is why you have to bring up your right to religion, your right to culture. See, when you let these government entities try to handle it, they're going to sidestep it. You know why? It's very simple. They don't have a right to talk about religion. They can't talk about religion or anything related to your culture in those courtrooms. So they're not going to be able to do anything for you. See, they're seeking remedy from people who cannot even give it to them. All right? A lot of tribes did not want to say the United States had taken their land. They wanted assurances from the United States that they could practice their religion freely and they would not have their children subject to compulsory school attendance hundreds of miles from their home. They wanted a great many cultural freedoms and protection, and that is what they thought a settlement with the United States would be. That you would finally settle accounts and live together as the wampum belt shows. At any time between 1944 and the present, Congress could have held oversight hearings. It called those bureaucrats and commissions to account, and it could have turned that situation around so that we would not have the volatility out in Indian country that we have today. The second example is the recent passage of the American Indian Religious Freedom Act. This resolution is as innocuous as can be. Representative Morris Udall got on the floor of the House of Representatives and he said this is just an expression of federal intent. It is not going to affect any laws. Nevertheless, the resolution directed federal agencies to go into consultation with Indians before they proceed with their programs in any instance where it would conflict with Indian religion or practice of traditional things. The attacks on traditional religion since the passage of that resolution are absolutely astounding. There has been more litigation on Indian religious questions since Congress attempted to clarify that than there were before. The courts, with no direction from the Congress, have now evolved a doctrine that an Indian religious practice must be the central core of the religion in order to be protected. A good many Indian religious practices are now described as merely cultural artifacts and not religious practices at all. So now the government is determining what is a religious practice. In the last 10 years, we have come under a more severe oppression of religious freedom than we did before Congress passed the American Indian Religious Freedoms Resolution. So my request in the hearing is for you to take to your colleagues in Congress to demand that national honor be demonstrated. And part of this national honor would be a clarification of the federal laws and the interpretation of federal laws that are applied to American Indians. The second thing would be severe oversight hearings on federal agencies dealing with American Indians. It is quite an embarrassment to me and to other people in this room, and I am sure to you, Senator, to realize at this stage of American life, there is virtually no accountability in the federal government, particularly in the executive branch, and specifically with relation to us in the Department of the Interior and the Bureau of Indian Affairs. If Congress chooses to maintain it has a plenary power over Indians, then we think the plenary power should be used in a positive manner, and the federal agencies dealing with American Indians should be held to account and held to the highest standard of behavior, and that the whole federal government should recognize that status of independent domestic nations as quite a bit of substantial content found in the Constitution and in the American history. In the next couple of years, if we could have hearings on the substantive legal issues and then get some very short declaratory and clarification statutes defining what Indian rights are, that would give us the necessary leverage and the standing to then help do better in defending our own rights. In that spirit, I hope this resolution simply marks the beginning of what could be a new and very aggressive defense of American Indians' rights and their communities. Thank you very much. So there you have it. That professor speaking very plainly and directly about what was going on. And I'm reading this because it shows you what not to do. Because they're going to the very entity that don't want to give them their rights, who's actually robbing them of their rights. You have to do it a different way. So, all right. Thank you for listening to that. Tune in because there's more to come. Because there's a lot of remedy here. Just the different paragraphs I'm reading. And I'll be sharing that pretty soon in my private membership. All right. Peace.